Good morning. This is a meeting of the Subcommittee on Patents General Amendment Rules 2019. We have reached the appointed time to start, and a quorum has been formed. So we'll proceed to the election of a chairman. We need a member making the nomination verbally and seconded by another member in order that the nomination is considered valid. Nominations. Mr. Holden Chow, I nominate Mr. Felix Chung. Mr. Chung, do you accept the nomination? Yes. Do we have a seconder? Mr. Paul Chan seconds the nomination. On the count of three, or do we have another nomination? 1, 2, 3. All right, Mr. Chung, Mr. Felix Chung, please take the chair. Okay, thank you.
好啦，多謝大家。咁啊，
Thank you, members. Do we need to elect a deputy chairman? No. Okay. So we can begin today's meeting. The subject matter is Patents General Amendment Rules 2019, or just Amendment Rules. Please find the following background documents. There's one from the CITB, the electrical brief issued on the 13th of March 2019. File reference CITB 06/18/23. And we have a Legal Service Division report, LS 59/1819. And also a background brief from our Secretariat, CB1 1816, bracket 02. With regard to the drafting of the regulation, please refer to CB1 1816 1819, bracket 03, issued by our legal advisor. I now invite the government to brief us on about the contents of the amendment rules. For today's meeting, we have Ms. Alice Choi, Principal Assistant Secretary for Commerce and Economic Development, Ms. Vivian Chan, Assistant Secretary, and Mr. Thomas Chung from the IPD, and Mr. Jonathan Look, Senior Government Counsel, Mr. Salvador Chung, Government Counsel, Mr. Derek Lau, Senior Solicitor from IPD, Mr. Derek Kwok, Solicitor from IPD. Over to the administration for an introduction of the amendment rules. We have been striving to improve our IP system. Patents as a system to protect invention is an important part of that. In 2016, the Legislative Council enacted the Patents Amendment Ordinance, or the Amendment Ordinance, to provide a legal framework for short-term patents, so that our IP system has moved into a new era. After the implementation of an original grant patent system, applicants can apply for such patent to be granted in Hong Kong instead of going to one of the three foreign jurisdictions to apply for the same, and only after the publication of the patent application would the applicant get any protection under the re-registration system. And under the original grant system, the registrar will be required to conduct a substantive examination after the grant. And we have this new patent system. Although the amendment ordinance has provided the essential legal framework for the new patent system, we still need to amend the Patents General rules to come up with detailed in the practice and implementation, as well as the fees and charges under various provisions. As a result, the registrar would exercise his power under Section 149 to come up with the Patents General Amendment Rules 2019. We intend to introduce the new patent system within 2019. That's why we need to amend the Patents General Rules expeditiously, and then subsequent to that, we would proceed to the procedure to set the commencement dates of the relevant new rules. There are technical aspects in the rules. For example, there are procedures for the application and granting of original grant patent system, including the submission of information and a detailed arrangement for the assessment and granting of patent. For example, the procedure pertaining to the request for re-examination. Secondly, there are provisions on substantive examination of the refined short-term patent system. This is about the post-grant substantive examination of an short-term patent. The amendment rules would provide for the procedure for the substantive examination and also the examination of applications, which are similar to those pertaining to the original grant patent system. And then under the new patent system, we have a new fees and charges, which will be provided under the rules. Any fees and for chargeable services can be found in Schedule 2. The amendment rules would amend Schedule 2 in respect to the fees and charges payable, and also the new fees and charges payable under the new patent system. In adjusting the fees and charges, we've followed the statutory requirements in the patents ordinance and also the government's principle of user pay principle and full cost recovery. We understand that the structure of fees must be competitive, so that the user would be given an incentive to use the new system. So we have looked at other jurisdictions and the fees and charges that they ask. We believe that the fees that we are asking will be comparable to those jurisdictions. And secondly, there are some technical and consequential amendments. Apart from providing for the new patent system so that it can operate smoothly, the amendment rules also contain certain technical and consequential amendments, such as miscellaneous rules, such as the claim without prejudice disclosure, such as the use of the amendments containing to the amino acid chemicals, non-prejudicial disclosure, and microorganisms. We would, depending on the progress of the preparations, set the commencement date later through the gazetted of notice. And as Secretary for the Commerce and Economic Development would align the commencement dates of different amendment rules so that they would commence on the same day. In the process, we have consulted the sector, the major professional and representative bodies of patent practitioners, and in general, they support the legislative proposal. They consider the proposals reasonable and comprehensive. And we have also briefed the electrical panel on commerce and industry. The panel supported in principle the legislative proposals. We think that the new patent system can improve our IP system and also to promote the long-term development of as a hub for IP right trading, and it would also provide a direct route for the application of a grant of patent so that inventors, applicants, and also startups and SMEs can submit a standard application for the grant of patent in Hong Kong. As for the post-grant, substantive examination system can improve the credibility and prevent abuse, and also to make it more cost-effective for those who seek to get protection under short-term patent system. All in all, this would be more convenient for applicants and inventors. This would be driving new impetus for our economic development. Chairman, members, my colleagues and I would do what we can to assist your scrutiny. I hope members can do this expeditiously so that we can implement the new system very soon. All right, members, questions? Mr. Houghton Chow? We have sufficient time, so I don't want to impose any time limit. Thank you, Chairman. I want to clarify the background. I'm not a member of the CI panel. We can see in the paper today that there are two parts. Under the amendment rules, we expect that you need more manpower. You need to hire more people to handle patent applications. But the paper briefly mentioned that this would mean that more manpower will be needed in the patent practitioners field. So I would like to know whether the relevant departments will need to get more manpower. Do you have any ballpark estimate on the additional manpower required? That's my question. Chairman, who can take this question? Mr. Chan. Thank you, Mr. Chow, for your question. At present, well, we only conduct formal examination for patents. So we don't need people with technical background. Under the new system, well, we secure new resources to recruit examiners who have technical backgrounds, who have experience in the patent field. Actually, we have expanded the establishment of the IPD. Through open recruitment, we have recruited 3 senior intellectual property examiners as to be engaged as patent examiners, and there are also 2 grade 1 IP examiner who would assist in the process. The patent examination division now has 3 senior examiner, IP examiner, and 2 IP examiner 1 in the third quarter. These new recruits will gradually report for duty. So in the initial stage, we have these people with engineering backgrounds who have experience in the patent field to assist us in handling the cases under the new patent system, which would involve not just formal examination, but substantive examination That is to say, we'll look at whether the applications fulfill the conditions for the purpose of a grant of patent.
Thank you. Well, it's clear that you have a plan. You've already got some manpower ready. Since it is an ongoing system, I believe you will also review your manpower situation from time to time. At the start, at least, we have a group of experienced personnel to handle the applications, and I believe you will maintain your flexibility and add more manpower if necessary. According to the paper, is a rather big change in the system. That's only a point of view. Any further supplement from the administration? Yes, I thank Mr. Chow for his view. That's a reform in the system, and this is the first time we introduced the OGP system, and we have the manpower ready. In the future, with further development, we will monitor very closely the increase in number of applications and the areas of experience and technology which require additional manpower. And then through existing system, we will seek more resources to expand the registrar's office and also to cover the area which we have the demand. Now, do you redeploy your officers within the IP department, or you get additional resources to cope with the work? Chairman, with regard to the newly recruited senior IP examiners and IP examiner 1, we work through the existing system through the LegCo to get additional resources to recruit them. As for the scale or establishment of the IP examiner, we have only one examiner who has engineering background, and that is through internal deployment or redeployment. The other examiners are new recruits, and additional resources have been obtained, and that is an expansion of the registrar's office. And therefore, we cannot do it through internal redeployment. Have you got the new resources? Yes, we have applied for that. Have that been approved? Most of the examiners, except one, IP examiner 1, who will take office in the third quarter. As for others, through open recruitment, in the first quarter of last year, they came to our office, take up the office, and have helped us in establishing an internal system, and they will be responsible for examining the cases under the new system. Do members have further questions? If not, then I have one more. Now, it's said here that the new system or rather, the new patents will be filed with the registrar, and the registrar may object. And there is a mechanism for the applicant to apply for review of the decision of the registrar. So will the registrar also conduct the review? And then he will decide whether he accepts the application for review or not. If the registrar has rejected the original application, he is also the one who reviews the same thing. So would there be an independent review mechanism? Chairman, the procedure is like this. There are two types of examinations, formal examination and substantive examination. After substantive examination, the registrar will decide whether the application will be entertained or not. In the examination, under the amendment ordinance, there are procedures to ensure that the applicant will have ample opportunities to respond to the objections raised by the registrar. If the registrar is of the view that finally he is not satisfied that the application fulfills all the requirements, then he will give a provisional notice, provisional objection notice. The applicant can go through the review mechanism. In the review, the registrar will look at the case once again in respect of whether he can be satisfied that the application meets the requirements. The applicant can provide further documents, make submissions, amend certain claims and specifications in order to convince the registrar that the application is in line with the examination requirements. Chairman, your question is this. The provisional decision is issued by the registrar, and the final decision is also issued by the registrar, so is that an independent mechanism? I just want to say that under the trademark system, the practice is the same. If we are to reject a trademark application, we'll give a chance to the applicant to be heard. And in the hearing, we have colleagues to hear and look again at the application. Under the registrar's office, there will be different colleagues who will review the case to ensure that each case is dealt with fairly and squarely. At the end of the day, the decision is the registrar's decision. Yet, we will have administrative arrangements to make sure that the process is fair. Whether it is granted or refused, the statutory power rests with the registrar. It's the registrar's decision. Yes, of course, I know that. Of course, it is registrar who grants the application. But with regard to review, it has to be fair. If there is no independent mechanism, then it will not be fair. Have you compared the situation, current situation, or your proposal with other patent offices outside Hong Kong? Do they have an independent appeal mechanism? How can you deal with the bias? It is the application is going nowhere. What's the point of making a review? Are there overseas examples which have an independent review mechanism? Say, if the registrar rejects the review, is there a further appeal mechanism? Generally speaking, Mr. Chairman, the review is to be done by the registrar's office. In overseas jurisdictions, say in the mainland, they have a similar review mechanism. In the review mechanism, a department will be specifically tasked with the work of conducting the review. They have more cases and a bigger establishment. In Hong Kong, whether it's in the initial application or in the review, the patent office of the IP department will deal with them. Generally speaking, the principle is that those who deal with review, those colleagues who deal with review, the review will be different from those who deal with the original application. So it will be another group of colleagues who conducts the review to check whether some arguments or details have been overlooked or have not been given due weighting, and whether there is any new submission, and also whether there are new arguments made by the applicant. So there will not be any bias. The same case will not be considered by the same colleague from the beginning to the end, covering both the original application and the review. Under the provisions of the Patents Ordinance, the applicant has the right to appeal to the court. So there are checks and balances. We are under the jurisdiction of the court, and if the applicant decides to appeal to the court, then he will have to explain to the court what mistakes have been made by the registrar. The court will listen to the whole case. So finally, the mechanism is subject to the jurisdiction of the court. On the whole, the system is fair and square. Thank you. Ms. Olden Chow. Thank you, Chairman. That is also one more minor point. According to the paper, that is so-called the examination highway. Now, in the CNI panel June last year, such a point was made. According to the paper, do we not have this examination highway? The state IP commission is one of the alternative. Have you talked with the country, our country, or the authorities of our country, or have you talked with overseas jurisdictions? What are the merits of having the proposal in place? Yes, Mr. Jiang. I thank Mr. Chow for the question. The examination highway is very important to the development of our patent system. And let me explain the operation of the examination highway. It is to establish the application for corresponding applications, and the corresponding authorities can make use of reports in other corresponding jurisdictions to speed up the decision for corresponding or matching patent applications. That is to facilitate the application of patents in different countries. In the world, there is no mutual recognition system. So if you have a patent in jurisdiction A, then jurisdiction B will automatically grant the patent simply because of mutual agreements. There has to be an application and approval process. There are different patent offices in the world. They do have such examination highway, which is administrative arrangements. Say if a patent office of a certain jurisdiction has gone through a search and examination process, then existing documents can be relied upon to conduct the examination. Another patent office does not need to conduct the search and related examination again. But this is not binding. Say jurisdiction A has granted the patent. It doesn't mean that jurisdiction B will automatically grant the patents. They have to go through the same procedures. The reference is to the documentary proofs. With regard to the work of the IP department in dealing with this, we agree that if we have an examination highway, if we can have administrative arrangements with relevant authorities, it will help to promote our new patent system.
This will also facilitate the applicants when they apply for the grant of patent in another patent authority. We have started to talk to the state IP authority, IP administration authority, on whether there will be an expedited examination arrangement. This is ongoing. As for the discussion with other IP or patent officers in other jurisdictions, I think the first thing to do here is to establish our patent system so that we can gain some experience, expand our scope of operation, and then we can persuade other patent officers, especially those established ones, that Hong Kong is capable of doing both substantive and formal examinations. And it's hoped that through our examination, through the grant of examination reports, we can prove that we are technically capable of doing this. And these require time, and so that we can persuade other patent officers. We must show them that we are capable of doing this, because other patent officers would only agree to have such an administrative arrangement established if they think that the corresponding patent office in another jurisdiction has the necessary capacity. So we will accept applications under the new system. We gain the experience, and then we gain the credibility and recognition. When the conditions are more mature, then we'll be in a position to establish to discuss the establishment of a high-weight application procedure with other patent offices. So we agree that this is important, but we need to start the new system first. We need to gain experience, but we will not forget that this is the way to go. Mr. Houghton Chow, I thank the official for the detailed response. I can understand the point. You need to accumulate some experience. You must have handled a certain number of cases before you can persuade other patent officers to come up with high-weight applications arrangement. Well, actually, China is number one in terms of the number of applications submitted for the grant of patent. So you see, what I have just said is mainly my personal comments. Well, the patent is to last for 20 years. And you need to get, first of all, a term of 3 years, and then it will be renewed annually for up to 20 years. What would happen after the expiry of 20 years? In Hong Kong, standard patent protection will last only at a maximum for 20 years. After 20 years, the patent will be in the public domain. Everyone can use the patent. Through the patent system, we offer for a limited duration an exclusive right to the patent proprietor to make the best use of the invention during the patent period to have some economic gains. After 20 years has passed, the invention will be in the public domain. That means to say other people can use the same invention without the need to get the consent of the patent proprietor. We know technology improves one layer upon another. A new technology would evolve and gets improvement through the improvement of old technology. So maximum protection period is 20 years for standard grant of patent. That's my response to your question. For short-term patent, the maximum term is 8 years. Can a short-term patent be converted into a standard patent? Actually, we're talking about two different subsystems. standard patent has a term of 20 years. For short-term patent, after the localization of local patent laws in 1997, we have introduced this short-term patent system in Hong Kong. This is about protection invention with a shorter commercial life cycle. So we offer 80 years. So in response to your question, can a short-term patent be converted into the standard patent? Well, under the law, after the grant of a short-term patent, the same invention will not be eligible for the grant of a standard patent, because the short-term patent has been published out when the grant is made. So the validity will be challenged if the same invention is applied under the standard patent system. If an applicant applies for a short-term patent in Hong Kong, and after that is granted, the submission date of the short-term patent will be the basis on the application of another patent grant in another patent authority. And now, at present, they have to go to the three designated patent offices. And after the publication of the patent application in those by those offices, they will come back to Hong Kong under the re-registration system. But there's a possibility that people may challenge the application on the so-called dual patent or duplicated patent grants, because a patent proprietor cannot have two patents in respect of the same invention. So briefly, a short-term patent is different from a standard patent, and one cannot be converted into another one. Can you give us some examples? What kind of short-term patents are we going to see? What products are involved? Usually, under the STP system, we are talking about simple inventions, because the number of independent claims is only limited to one. But for no ordinary patent system, there is no limit to the number of claims, independent claims. You can have one, you can have more than one, or many, many claims. For STP is usually about simple inventions in the transportation field. We have had recently a case in the court. So the invention is simpler and it's not very complicated. In Hong Kong, the criteria in the grant of short-term patent and ordinary patent are the same, unlike other patent offices, whereby the requirements under the STP system would be lower. But in Hong Kong, we want to have a simple application procedure to make it convenient. And the applicant can directly file an application in Hong Kong. Instead of relying on the existing re-registration procedure, under the re-registration system, they will have to apply to any one of the three designated patent office, and they can only come back after the publication of the application. So if an applicant doesn't want to do that in a foreign patent office, they can simply apply for short-term patent protection in Hong Kong. You talk about the rights. Strategically speaking, the right of the applicant. They can apply for an ordinary patent grant, or they can apply for short-term patent. Is that the correct understanding? Oh yes, it's about the strategy of the applicant, who may consider different factors and the situation in different markets. Different applicants would come to different decisions, but they must be clear about the fact that they cannot very easily convert a short-term patent grant into a patent grant. We have now established a system whereby more options are open to the applicant. They can apply for STP, or they can apply for OGP, original grant patent. We just want to facilitate the applicant in making their decisions, making their strategic decisions. Well, one cannot convert an STP to an OGP in Hong Kong, but they can go to the UK, go to another patent office, comply with the procedure, and then they come back for the grant of an OGP in Hong Kong, although there may be a possibility that a third party may object to this. So why can't we allow this in Hong Kong? Instead of asking them to make a detour to a foreign patent office and ask for the conversion and allow the conversion to be done in Hong Kong. Let me clarify this. When I talk about the procedure whereby after the grant of STP, the applicant would so-called make a detour, submit the application in another patent office and come back for registration. I'm talking about the existing patent. At present, if you want to get a grant of 20 years of patent, you have to go to one of the 3 designated foreign offices, file applications, and then after the grant is made, you come back for re-registration. After the introduction of these OGP system in Hong Kong, the applicant will not need to go to another designated patent office. They can apply for OGP system in Hong Kong, and he will get a grant of 20 years. Although since we don't have an original grant patent system in Hong Kong at present, so an applicant who wants to get a patent protection in Hong Kong, they must make the so-called detour and come back to Hong Kong to get the protection he needs. And with the support of LegCo, after we have enacted all the relevant amendment rules, we would have established in Hong Kong a new OGP system, and the applicant would no need to go through that convoluted application procedure. They can apply for original grant patent system in Hong Kong, and the examination of the application will be carried out in Hong Kong. There will be no need to make the so-called detour anymore. Mr. Wu Chi-wai, do you have any question to raise since you just joined us? No? All right. Other members? No? Then I would like to ask a follow-up question. We are talking about 4 parts: OGP, STP, fees, and technical and consequential amendments. With regard to the technical and consequential amendments, and we have the first one, the non-prejudicial disclosure. What do you mean by non-prejudicial disclosure? Which on the requirement for claiming such disclosure which occur no earlier than 6 months before the date of filing of the relevant OGP application of an application underlying OGP application. What do you mean by that? As I've explained, when you file an application, you cannot publish before the filing of application. I cannot display, for example, I cannot show the invention to other people and then I apply for patent grant, so that the inventiveness would not be satisfied. So you have to keep it secret, and then you file an application before you make this disclosure.
Different patent authorities do allow this. Before an application has been made, the invention has been disclosed, but such a disclosure is not regarded as prejudicial disclosure. In the substantive examination process, the examiner can disregard such a disclosure. But this disclosure should be very specific and very limited. Say, with regard to an OGP application which is non-prejudicial disclosure, which is in relation to non-prejudicial prejudicial disclosure, that may mean, say, in an exhibition before the application is made, and such a product or innovation has been displayed. Such a display is not regarded as prejudicial disclosure. An applicant or an innovator in conducting the innovation has cooperated with some other people, and there is a breach of trust on the other party to disclose the innovation. That's an obvious abuse. In the application process, if the applicant can satisfy the examiner that there is abuse or there is an abuse, then that has not obtained, the disclosure has not obtained the agreement of the innovator, then such a disclosure is non-prejudicial. In our re-registration system, in our standard patent system, and also in our STP, such mechanism is available, and there are provisions to regulate the claim for non-prejudicial disclosure. We just apply the same principle equally to the new OGP. With the new system, we need the provisions to materialize the legal principle. So that's the meaning of claim for non-prejudicial disclosure. Now, even the so-called prejudicial disclosure is made, and that would only prejudice the innovator. Now, he has suffered, and you don't allow the registration. There are three very important requirements. First, the innovation or innovative character. No related invention has been disclosed in this world, so that no other one will consider that this innovation has existed before the application. So it is dead when it has seen daylight. Before, there should not be any prior disclosure. We regard the disclosure as a prejudicial disclosure, and this disclosure will lead to the consequence that the applicant will not be able to get the patent. But he cannot be barred from selling the product. He can still sell the product, but he cannot get a patent in respect of the relevant innovation. We follow the existing rules and principles in doing the examination. If there is any dispute on the validity of a patent in the local jurisdiction or in overseas jurisdiction, when there is a dispute on patent, usually the argument is that the application does not have novelty, or because the invention has existed before the day of application. That's the rule of the game. Generally speaking, in an R&D process, you cannot just do your R&D within one room behind closed doors. You need to get funding. You need to speak to investors to attract them to invest in your invention. You have to explain to them the business opportunities, and that's usually done. The disclosure is usually done within an agreement, within a non-disclosure agreement. And after the agreement has been signed, then the innovation is then explained. So the other person cannot claim that I have seen that under some other day before the application. I'll follow that up after that, Mr. Wu and Mr. Chow. You refer to innovations, and the patent can only be registered with innovations. If something has been, some part of it has been disclosed, and if it is prejudicial, yet it doesn't appear in other parts of the world, and you've signed an NDA. If you're an investor, then you sign NDA. But if you I don't have any investor. I do my own invention or innovation, and I disclose a part of it. Then, and there is no such thing in other parts of the world. Will that prevent me from registering the patent? When the relevant invention is made as the subject of an application for patent, when I have made the application, my rights have been protected, and then I can go forward to make disclosures and also seek investments. Generally speaking, if such things are done after the day of application for a patent, then there is no problem. But before that day, if there is any prejudicial disclosure, generally speaking, the examination system is not regional. The disclosure is global. If it is documented, say on the first of the day, such an invention has been made known to the world, and the application for patent is done on the first day of February, then as far as the date of the 1st of February is concerned, the application is not is lack of novelty. That is nothing new. That is lack of patentability. So the patent authorities adopt the same principle to decide whether to decide on the patentability of the matter. The court based it on international principles. If I disclose it in January and then make an application in February, but the technology doesn't appear in other parts of the world, how can you say that it has lacked novelty, still new? The date for decision is on the 1st of February if the application is on that date. So the court will look at it from the perspective of that date. The court will decide whether before the 1st of February the innovation has been made known to the world. Even if the disclosure is made by the applicant before the 1st of February, according to the law, the so-called innovation or novelty has been lost. Say if the disclosure is made was made in the U.S., then it doesn't mean that Hong Kong can ignore the disclosure in the U.S. if the application is made in Hong Kong. The examiner looks at the documents available to check whether on the date of application there is novelty in respect of the application. Even if I disclose this in a certain part of the world and other countries do not know that, as far as the date of application is concerned, if the date is later, application date is later than the date of disclosure, then the novelty has disappeared. Mr. Wu Chi-wai, with regard to this OGP arrangement, is it a kind of one-stop shop service through the assistance of the mainland authorities? Now we'll have a more convenient channel. I just want to know whether this is the arrangement. If you have OGP in Hong Kong, that's a local arrangement, but this local patent is only limited to Hong Kong, then the applicant will only has rights in Hong Kong. Can that patent be extended to other parts of the world? Earlier on, we had the PPH. We discussed that before, the patent prosecution highway. And if that is the case, then will our own OGP be subject to international standards? If not, then the applicant will have to also take into account the overseas standards. And is it related to the non-prejudice disclosure issue? In the 60s, Professor Cao wrote his thesis on the operation of the optical cables. And if he has not, if he hadn't registered his patent before he disclosed his thesis, or then would he have lost his patent or novelty? The OGP, let me speak on the relationship of the OGP and future development. The statutory protection of the OGP only applies to Hong Kong only applies to areas within the territory of Hong Kong. As for Mr. Wu's reference to PPH, that's an administrative procedure. They are two different concepts, but they are related. If we can work with other patent authorities and get a PPH, then we need to have our own experience and also build up a great number of cases. We must have enough capital or chips, to put it bluntly, to explore the possibility of setting up a PPH with other patent authorities. Assuming that there is a PPH arrangement between Hong Kong and other overseas authorities, then when an applicant files an application or has obtained a patent from another jurisdiction, and if that jurisdiction has a PPH arrangement with Hong Kong, then jurisdiction, I call it the overseas jurisdiction B, then jurisdiction B can ask for documents from our registrar's office to facilitate the examination of the applicant in that jurisdiction, in jurisdiction B. This is an administrative arrangement to facilitate the application and granting process, so that within a short period of time, patent protection is given in different or is obtained in different jurisdictions. Our strategy is this.
We must establish our OGP system first. We start the examination of applications, and then we have the bargaining chips to negotiate with other patent officers and to show them that our examination work is of high quality and we have the experience, and so that they can have more confidence in our assessment work, examination work. Then we can consider the PPH. But PPH is not binding in nature. That is to say, although another jurisdiction, another patent office agrees to take reference from the search documents and other documents from the other patent office, it doesn't mean that the application will be granted as if the two applications are lumped together. Every patent office, every jurisdictions would have to assess the application independently according to their own criteria. But of course, if another patent office can provide the documentation concerning the search and the examination process, that would expedite the procedure. I don't know whether I have answered Mr. Wu's question. I understand that. Thank you. The second question is the example of Professor Charles Cowell's invention of optic fiber, and in respect of the point of non-prejudicial disclosure. Of course, Dr. Cowell's, Professor Cowell's disclosure was in the form of a thesis, which is the basis of the invention of optic fibers. So I use that example to ask whether the Professor Cowell should have applied for a patent before the thesis was disclosed, or else he would have lost the chance to have the invention patented. My answer to this question is this. If Professor Cowell, before making public or publish his findings or his research findings and invention, he would have already given up his potential right to get patent protection. But different researchers in different fields may consider different factors. If he wanted this to be in the public domain and he didn't want to get any protection or any patent right, like Professor Cowell, well, many people commented Professor Cowell for doing this because he opted to not to pursue the patent right to protect the fruit of his scientific research. And that had benefited the entire field of scientific research. The legal principle is that if you want to get patent protection, the invention must have the necessary novelty. And that is before the researcher publishes a thesis or discloses his invention, and if he wants to get patent protection, he must submit an application for the grant of a patent first. That's the only way to protect the fulfillment of novelty. And if he immediately discloses the findings of his research without seeking patent application, well, it's something that we should all respect. That's his decision. Well, I understand the point. I was just asking a question by using a real example. And I think that's why Professor Carl was considered so great. So the non-prejudicial disclosure is considered whether the thesis was published before the filing of an application, and after the thesis has been published, then the novelty is lost. If someone relies on that finding to create further inventions, what would happen? What's the relationship between the two? Thank you for your question. If the invention has been made public and someone make use of the same invention to file an application, then there's also the question of novelty. No, I want to give you an example. In the thesis, he thought the use of optic fiber would create breakthroughs in communications. And then subsequently, there were people who thought about using the optic fiber as the basis for inventing less invasive tools for the operations, for medical operations. Would that still fulfill the requirement of novelty for the second invention? Let me supplement. If that's for the same invention, if it has been made public, then another party cannot file a patent application on the basis of the same invention. But of course, all scientific achievements can be considered as an invention based on past inventions. It's a layered structure. If someone invent another thing on the basis of past invention, it can also still meet the requirement of novelty. It can be the subject of a patent application. But the person cannot use the invention made by Professor Carl to file an application. There must be more input, more achievements, new inventive content arising from the new scientific research that would be required for a new application. Well, I have read the background brief from the Secretariat. I noticed that our legal advisor has written a letter to the administration. Under the new patent system, the registrar can issue a provisional objection or refusal, leading to subsequently a final rejection. So the question is, with the issue of issuance of the provisional refusal, is it at that point the applicants cannot make any disclosure or give any indication of the invention? He cannot tell any outside party that he has this patent application. Otherwise, it would be an offense, or is it that it would be the case only when the final refusal is granted can he make the claim of that invention, the subject matter of the patent application, while there's a provisional refusal? The legal advisor has asked some questions about the offenses under the ordinance, and that is to say, if someone has not filed a patent application or does not own a patent right, and he makes a claim to the same effect, is an offense under the ordinance. And here we're talking about a provisional decision. The registrar issue a provisional reason, indicating his provisional refusal to the application. But the applicant at that point can seek a review. Under the provisions, the patent application is regarded having been rejected. The rejection means that the final rejection has been made. If this is a provisional decision, the applicant has a right to seek a review of the registrar's decision. So, look from that perspective, the procedure has not been completed. It's still ongoing. So, before the registrar issue a final decision of refusal or rejection, the applicant is regarded as pending. Before a final decision is made, is considered pending. In other words, the applicant cannot make claims which is false, or he cannot claim that he has done something which he hasn't. He should not claim that he has been granted a patent. Of course, this is not allowed under the ordinance. Or he cannot claim that the patent is okay. But if the applicant is just saying that, well, this patent application is pending, is being processed, and although there is a provisional decision to refuse the application, at the point where he makes the remark that the application is ongoing, and since he has still got the right to seek a review, if that's the case, then he has not committed an offense, because in that provision that creates the offense is about the registrar having made a final decision of refusal. If that's the case, then the applicant cannot claim that the application is being processed, or he owns a patent. He has been granted a patent. Thank you. That's very clear. Can you tell us that from your experience, from the time the so-called provisional refusal to the time the registrar is able to issue a final decision? How long would it take?
幾個月啦、半年啦，或者甚至乎會牽涉到1年到嘅咧。我純粹想了解下啫，係唔該。
How much time would be needed for the duration? But that depends on the case. It's different. It can be a few months, or it can be years. Well, let me explain. After the registrar has issued the provisional decision, the applicant has 2 months to decide whether he would like to seek a review. He can file a request immediately, or he can do this after before the 2 months is up. And that 2-month period can be extended at the request of the applicant. And then the registrar, upon receipt of the request to review, he will look at the merits of the case, and the registrar may issue the review notices. And the applicant will be given some time to respond. Usually it should be 2 months. The applicant will be given 2 months to respond to the views taken by the registrar, and then the registrar would, upon receipt the response from the applicant, consider the matter, and then there will be another 2 months, and the applicant can also seek extension. So decide of the system is such that the applicant will be given sufficient time to persuade the registrar that the application is approvable, but this will not go on forever and ever. At some point, the registrar would have to come to a decision that you have got no grounds. I've considered all the grounds and justification that you have submitted. Then he would come to the final decision. That is to say, the application is refused.
Of course, it is dependent on individual circumstances. If it is a simple case, then the applicant, after exhausting all his arguments, then the director or the registrar can speedily notify the applicant that the application is refused. The provisions are very flexible. They do not require the registrar to issue how many notices for further information. Say if we feel that they have not given us ample information, then we give them a chance to make further submissions. And we also give them a chance to be heard. And they can also apply for review. They can give a, if the case is very simple, then one round of opinions or 2 rounds of opinions will deal with the case. So to answer members' question, it can take a few months. And if it is complicated, it is not impossible that it may last for a year. Thank you. I have no further questions, but I have a point here. I think there is a need for public education. Well, if it is an ordinary case, then there's no problem. But if someone wants to drive through a loophole, the provisional notices have no specific time frame. They may also abuse the system and try to get benefits through a lengthened application process. If the patent is under application, then they may also make use of this as a way of getting benefits. That's a point of view. I don't need any reply to that. The legal advisor has something to say. Now, since Mr. Chow has referred to this, let me give you the full picture. Now, under the ordinance, Section 143, if an application is refused or has been refused, then the applicant cannot say that the patent is under application. Now, what we have to deal with is this. This is the PGAR. The director can issue a provisional refusal notice. There is the word refusal. So the registrar has already issued a refusal notice. An ordinary citizen, having seen the word refuse or refusal, may have the understanding that the application has been refused. The one who try to get benefits from this lengthy process may still say that the application is pending. So in terms of the using of terms, can something be more definite so that people will not have a misunderstanding? According to the interpretation, the conclusion is that refusal under the principal ordinance does not cover the provisional refusal notice. Can that be put down more clearly or categorically? I think That's about a technical point, and we need more time to think about it. We may not be able to provide the answer off the cuff. Okay, please then answer in writing. Yes, we will do so. Mr. Zhang also refers to criminal liability. Why applying for a patent involves criminal liability or culpability? Now, Chairman, let me clarify that the present application doesn't lead to the present amendment doesn't lead to any culpability. It suggests an enhanced patent system. Somebody has to apply for when applying for substantive examination, or somebody can apply for substantive examination, and a fee is involved. So the present amendments do not involve any legal or criminal liability, because I have heard that the word offense has been mentioned. Now, the legal advisor also raised this point. The offense or criminal liability refers to criminal liability under the principal ordinance. And such liability are not linked to the application. If somebody tries to change the record of the registrar's office, that is an offense. If an application has been made and the application has been refused, then the person claims that he has a patent in Hong Kong. That's misleading. That's not true. Then, according to the ordinance, principal ordinance, there is criminal liability. But it doesn't relate to the application of the patent. It is about anyone who makes certain claims, who makes misleading claims because of the application. And that is criminally liable. That's about making changes to certain records, and that leads to liability. Do members further questions? I want to ask members whether we need to conduct any public hearing to consult the public and relevant bodies in respect of the rules, the amendment rules. Is there any need to do that? No? No need? Okay, good. Well, if there is no need for a public hearing, then we have only 20 minutes left. We still have only 20 minutes left. So shall we leave the clause-by-clause study to the next meeting? The provisional date for the date of next meeting is 10:45, the 9th of April. The 9th of April, 10:45, which is a Tuesday. I hope we can finish clause-by-clause study the next meeting. As for the legislative timetable, the expiry, or rather, the amendment rules will come into operation on a date to be appointed by the registrar, and members may refer to the timetable. If we can complete the clause-by-clause scrutiny, and then on the 9th of April, then the date for making notice is the 10th of April, and the expiry date is the 17th of April for the expiry of the scrutiny period. Well, we can finish it at the next meeting, but we've passed the deadline for reporting to the House, and we may need to seek an extension, and the extension of the expiry period will be until the 8th of May. Yes, we need the next meeting. We hope to finish the scrutiny on the 9th of April. On the 17th of April, at the council meeting, I will move a resolution to seek extension of the expiry till the 8th of May. Without further questions, we can conclude our meeting today, and we hope that we can finish our study on the 9th of April. Thank you very much.